The following podcast contains opinion and commentary protected by the First Amendment and fair use. It may also contain adult themes, adult concepts, and adult language not suitable for children. Viewer discretion is advised.
Why do we have to, every time Rachel says something, you're just like, oh, you're not listening. It's just like, I don't get it. She is listening. She's listening to every word you say. And she's presenting something, and then you come back and shake your head and sigh.
Okay. Anyway.
Submit to an interview.
Wow. Stop. Well, if you let me. We're moving on to the next question. We're not gonna get very far with that. So
they can prove that this is not the first time she's done it. But okay. Even if you disagree with me,
I felt like I was juggling a flaming chainsaw while having my leg bitten by a German Shepherd. Okay. All right. We're moving on to the next question.
What lawyer ever says that?
Well, yeah. You're welcome that I gave you that's such an easy way to roast me.
Allegations, you know it's a possibility you might not win something. We're talking about the appeal.
There's no chance you lost this appeal.
Yeah.
You will have this.
Rachel, here, can I offer you like a cookie or something? What do you want me to say? What do you want me to say?
Not that. In our case, we like our case.
I shouldn't have said that. Can we move on? Okay.
Yeah. Well, pull it up. These statutes were invoked.
Yeah. Okay. Hang on. You're getting. Okay.
But show me a case that says that, because your cases don't. I've read them all now. Just give me a quote from Holgate. Just give me a quote from Holgate.
Can you hang on? Can you hang on for just a second here? Okay. Lord. Okay. You are pretending. Wait. If you want me to stay on this, you need to let me have fair opportunity to answer, okay?
David, of 58 minutes, you probably talked for 42 of them. I mean, come on, man.
Okay, guys.
Hold on.
Let me...
I got the
Rachel.
case there.
Oh,
There's
God.
only the Rule 11. Hold on. There's other authority. What was at issue in that case?
We got to move on. We got to move on from that.
So, is the whole point. Try to withdraw it. There were other issues before the court.
Oh, for God's sake. Okay, Steve, can we move on? Because we're not going to get...
And then you come back and shake your head and sigh.
I know,
He
but...
don't have any authority to infringe his copy or whatever, that I interfered with his...
But way before my time. Way before I was there.
Way before you there. Where are these children?
Okay, you ready?
Where are they, David? This is the one thing that I think everybody wants to know.
Okay.
She's still 6 months pregnant. Can I show my belly? How would she have a belly in November if she miscarried in July or August?
Look.
It's still not appropriate for her to include that finding of fact. Where are the people? There were reasons that her findings would have been inadmissible.
My Lord. Steve. Oh, my God.
And then Rachel gets 5 to 10 seconds before you sigh.
Read the emails with Clayton, the emails with Greg, the text messages with Mike. 5 that it is, but something that purports to be.
Whatever.
If you would have won, obviously, if you would have won, you would have gloated too.
Here, sign something saying that you raped me, that Laura was pregnant. I don't know what that would be. I mean, she's been running around subpoenaing things, apparently.
Welcome back to your favorite cubbyhole on the internet. And yes, we are back again. Because there's much insanity to be had. And as he threatened, he has filed. He has filed again. He has begun his death march. It sounds something like this. The evil emperor is on the march to the Supreme Court. But he first makes a pit stop. Oh, yes, he does. He makes a pit stop back at the Court of Appeals because, well, he can't leave well enough alone. And just like his client, Dingus the Douche Canoe.
The fucking douche canoe.
Doesn't like taking no for an answer, just like his client doesn't like taking no for an answer. So what are we going to do? We're going to beg. And a little whining and groveling and telling, not suggesting, but telling the appellate court how wrong they are and how only dipshit the defamatory douche canoe.
The fucking douche canoe.
Because, well, on Reality Steve, I think he did defame Clayton Echard by saying he ARPed not only Laura Owens, but he alleged he ARPed the women on The Bachelor. And in my opinion, and we may get to this, I don't want this thing to go on all night because I've got bedtime. It's the evening already. And this just appeared on the Reddit page because that's just how amazing all these people are. And here it is. Here it is. Fresh off the press. Well, this actually isn't fresh. The filing, I didn't look at much other than at the date at the bottom. And apparently this was filed on April 11. Not long ago. Oh, this is horse shit. All of this is just horse shit. This is really the written form of what we saw in the argument with Dingus the Douche Canoe getting fucked by Rachel Juarez and slightly less by Reality Steve. This is really all the same stuff by what little I skimmed ahead when I realized the stupid thing is 21 pages long of just more douche canoe bullshit. Or maybe I should say defamatory the douche canoe. Maybe we need a new name. The defamatory douche canoe? Whatever. In any case, I'm jumping all over the place because this is going nutty. It's going nutty, and it's going to keep going nutty until the roadblock is put up and all the barricades are put up and the court system says, "Thou shalt not pass go Dingus the Douche Canoe and Laura Owens." That's what it's going to take for this to come to an end of no longer torturing the judicial system. But, well, I don't think David has that sort of self-control because he would be smart enough to not suggest to his client publicly, who waived some of her right to attorney-client privilege by discussing about her maybe filing bankruptcy to avoid sanctions. Tell me that's not criminal. Come on. Come on. This is insane. He's insane. His client's insane. Not necessarily in the clinical sense, but, in the colloquial sense. Oh, my God. Save us from crazy people that just abuse the court system, and save us from lawyers that need to be disbarred and probably put away in prison. There was some discussion. This is another sidetrack because this is nothing but a bunch of drivel that we'll skim through very quickly. Schnitzel Ninja, the amazing and very resourceful, apparently, has dug into Dingus the Douche Canoe's past. And evidently, Dingus the Douche Canoe has a little bit of a criminal past. And allegedly, supposedly, was a criminal defendant for sexual assault. He was evidently, apparently, supposedly, allegedly. How many other words can we cram in here? How many more do we need to cram in here? He was a manager of a fast food restaurant, Schnitzel Ninja says. And he allegedly assaulted a 17-year-old young lady. And evidently he was much older. I'm not sure how much older, but enough to make it a problem. And he was facing a criminal trial, evidently. But, unfortunately, due to what would seem to be prosecutorial misconduct, he got let off. His case for criminal sexual assault was dismissed. And now he's the charming, well, how's that for being facetious? He's the lovely Dingus the Douche Canoe that we know today. And this is why he's so cocky. And this is why he's so arrogant and narcissistic and full of himself. He is an example of when the court system failed and failed to prosecute him for his alleged crimes. Now, it sounded like in that conversation that included Schnitzel Ninja and Megan Fox and others on Lauren Nighty's first installment of watching David get ass smacked by Rachel Juarez. Megan mentioned that she read some of the transcripts of that case before it got tossed out. And the things he's alleged to have done to this young lady are disgusting. And they're about as criminal as one could get. And it sounds like, had there not been prosecutorial misconduct, Laura Owens may not have had this guy as a lawyer to begin with at the end of this insanity. And hopefully this is the end of the insanity. It shouldn't go too much further, but we'll stretch it out for emotional appeal And as a warning, to watch out for crazy people like Laura Owens. Watch out for crazy people like her attorney, who I really hope is being fully investigated by Rachel Mitchell, the Maricopa County prosecutor, the Maricopa County Prosecutorial Office. Hopefully something will come of that. We watch and we wait. We keep our lamps trimmed and burning. One if by land, two if by sea. God, it's getting late. What can I say? It's late and there's bullshit to skim through. Oh, here we go. Maricopa County Superior Court. A motion for reconsideration by Dingus the Douche Canoe.
The fucking douche canoe.
Oh my God. I don't know if I really want to read all of this. I really don't. Because we know what it's going to say. We know he's going to tell, you're wrong, Court of Appeals. I know better than you. I'm a hack attorney who doesn't even carry malpractice insurance, so it seems. And I'm going to tell you how wrong you are on the law that you told me I was wrong on. So I'm going to tell you back, and I want you to reconsider this because I don't take no for an answer, and neither does Laura Owens, because she's a spoiled bitch who's never been put in her place. Well, that's my opinion of her, at least, and it will not change. It will not. The introduction. Laura Owens respectfully moves for reconsideration of this court's decision dated March 28th. Laura understands reconsideration is rarely granted and is not appropriate vehicle to rehash arguments previously raised. But he does. He does. I'll tell you that right now. What else is he going to do? He's just going to keep rehashing the same things, just like he did with Rachel. He's going to be an arrogant dick, and he's going to tell them how wrong they are. I just know it. And I suspect he might get slapped down right away if they respond at all. I don't know if they have to respond to that, or it would be a very short response. Denied. At the same time, Rule 22, see, this is where we can talk about reconsideration. I don't care. Here, the memorandum decision contains erroneous determinations, both of fact and law, which would directly affect... Yeah, sure. Please. Reconsideration is appropriate. No, it's not. You lost. Nothing is appropriate other than you losing. Discussion, structural error analysis, misstated errors in law. And this is where, he talks about Marchese and Rachel. Rachel was so beautiful, and saying how wrong he was about this. Violated due process. No. This court rejected Laura's arguments for several reasons. Due to the limited nature of reconsideration requests, Laura will not re-raise. But he's already raising them. He already What a stupid ass. Oh. Just by bringing up the Marchese thing, which was in his appeal. Shit. Instead, let's just move along. I'm going to give myself an aneurysm laughing at how bad this is. I'm no lawyer, but even I see how stupid. Is he lazy? Is he stupid? Or is he just an ambulance chaser? Just a clout shark? That's what we would like to know. Rachel Juarez tried to get that out of him, but he tap danced it. I really believe there's a due process violation. I'm going to be victorious. That guy may have Trump merchandise for a reason. Not to trash on all Trump people, but, well, some of you deserve it. If you are. And since he does have so much Trump merch, I'll bet dollars to donuts he voted Republican more than once in his life. You know, as many lawyers seem to do. It's amazing how some of those things go part and parcel. But at the risk of getting too political, I'll keep reading. Instead, Laura notes this court's own legal analysis of that point rests on an erroneous application of law. He's going to argue with them that they can't apply the raw. This is insane. This is exactly what Rachel told him. It's like, you don't understand law, David. And he's going to argue how everyone is wrong except him. What a stupid ass. Extrajudicial information. See, we're gonna do all that all over again. I thought we weren't raising the same issues all over again, but here we are. We're raising the same thing. Look, here's the same stuff. The statement is correct. It can contradict. Oh, Jesus. Stop it. Oh, let's see. Appearing sentence. The judge. Yeah. See, this is just going to be. This is the written diarrhea of what David was trying to argue with Rachel and lost terribly. Oh, we need to move on. The judge refused. See, he's reciting the case. He's reciting the case and trying to. Fuck. Ex parte communications. Yes, see. Nothing in a manual states prejudice is required or that a judge consider. David. I'm not a lawyer, and I can tell how terrible you are. He keeps going. He just keeps going, rambling on. We might get through this really fast. We're already at page 5, and he's just arguing the same things. Stagecoach trails, blah, 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 blah. I don't think they're going to entertain this. And then I think he's going to file to the Supreme Court, and then I think that's about where he's going to get a little more permanently slapped down. I hope. This is stupid. Let's see. Judicial rulings alone do not support a finding of bias or partiality without showing extrajudicial rulings. This rule has no application here. Laura's structural error argument was never based on judicial rulings alone. No, it's based on David's fictitious imagination of what he thinks the law says, which 2 courts now and a bunch of smart, I would say medium smart lawyers have even called him out on. Everyone has called him wrong, and he's just such a dick. He doesn't even. I'm stammering. I'm stammering because he's so stupid. The case says no such thing. Ugh. I'm not going to read the cases. It's not worth it. Because I'm quite sure that if we were to read the cases, everything we would reach the same conclusions that Rachel did. So all of this is toilet paper. All of it's toilet paper. Let's keep moving ahead. Reversal is mandatory because the trial court failed to make the required statutory findings to support. No. Is this Rule 26 again? Any bets? Anyone want to take any bets? The court is familiar with the procedural history of this case, so full discussion is unnecessary except to point few facts. No. The forum pleading. Oh, now we're going to try something a little bit different. In the forum pleading she filed, Laura checked a simple box asking the court to award reasonable parenting. You can't have parenting time when there's no children. You stupid fucks. And this is what started off this whole thing. She filed a petition for paternity. There were no babies. And then Clayton, figuring it out, challenged that and said, no, I'm going to challenge this. We're not going to let this just sort of disappear when you claim to no longer be magically pregnant after trying to show a fake pregnancy bump on primetime court camera. I talked about it. In an earlier episode. She was jiggling her, like Megan Fox said, that moon bump was up to her nipples. She was knocking her small tits around. It's true. It's totally true. The court footage is there, and it's hysterical to watch that thing just hang out up there. Oh, I'm cracking myself up. It's sad. Oh, let's see. Laura also submitted jerk pro forma, joint custody equal term. These 2 pleadings, Laura's pro se petition and generic parenting time, are the only pleadings ever filed in this case. So what? Yes. Here we go. In his response, there was a response, you stupid dumbass. Clayton denied paternity. Of course he did. Because you don't get pregnant from a blowjob. There will not be a new saint called Saint Laura Owens who got pregnant and gave non-birth. There was no birth. who gave nothing. Who gave nothing resembling any sort of babies or fetal anything. Nothing. As for parenting time, Clayton's response was entirely blank. Clayton never submitted it. So what? Why is he talking about this? Why is he talking about there was never any so what? Oh, get to the point, David. After Clayton retained counsel, the first substantive pleading file was I'm fast forwarding. Let's save us all from this headache. In that pleading, Clayton sought leave to add a request for Rule 26 sanctions. Oh, there it is. There it fucking is. So here we go. We're not arguing things over again, are we? But we're going to argue Rule 26 all over again. Sweet Jesus. So this, of course, is the filing to the initial Rule 26 filing for Clayton. That was later withdrawn. Nothing new there. So this is going to be more of Dingus the Douche Canoe.
The fucking douche canoe.
Trying to convince them of Rule 26 again, and they're just going to ignore it. I think they're just going to deny. I think they're not even going to give this two shits. Just days after Clayton raised the issue of Rule 26 sanctions, Laura retained counsel who apparently had a single phone discussion with counsel. Next day, Laura invoked the safe. No, what? Now he's claiming that Laura invoked safe harbor. He keeps trying to throw the same shriveled spaghetti up at the wall, hoping it will stick, and it just won't. I mean, that moldy, nasty stuff is just never going to stick. Show us the filing. You know, I don't know if we have the Register of Actions 37. Oh, maybe that's about her claiming she was no longer pregnant. So where's her invoking safe harbor? I mean, as Bruce the Moose from Oregon very rightly said, after it was declared, Rule 26, she let the time elapse. So there's no way that Rule 26 could ever work for any reason. Not only because of the timing of things, but just that the court, Judge Mata, awarded sanctions under other things. But dipshit the douche canoe, who's quote unquote not going to re-argue the same things, is right here re-arguing Rule 26. Oh my God, more Rule 26 sanctions. Yes, and he withdrew it. Yes, fine, great. The record is clear. The parties did spend blah 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 blah. Let me guess. We're going to argue that she didn't get her provisions for safe harbor. Is that where this is going? Are we getting ahead of ourselves? Any discussion of Rule 26 was simply irrelevant and unnecessary. Oh, this is what is going on here. Well, according to all the law, this is true. That any awarded fees and costs under 25, all of those, any discussion of Rule 26 is absolutely irrelevant and unnecessary. Absolutely. Because there's multiple vehicles under which the court can sanction, and not just Rule 26, as Rachel War has very articulately stated. And of course, Dingus the Douche Canoe.
The fucking douche canoe.
The defamatory douche canoe, in fact, just will not accept. He's not going to accept this either. He's not going to accept getting wouldn't that be beautiful if they smack him down a second time? Can the Court of Appeals do anything to his bar status? Wouldn't that be lovely? No, I think it's only the Supreme Court that can do that. But this loser needs to lose his license. He doesn't even understand the law. I'm an idiot, and I understand these things better than he does for some reason. I don't understand how that's possible, but it seems to be. Maybe I should have gone into law. Oh, that might have made life a little more interesting. The aspect of this court's decision was incorrect. As a matter of law, for a separate reason, the court appears to have overlooked. Yes, sure they did. Right. While this court correctly noted that Clayton generally asked for fees under another authority, and while the court is correct, like other statutes were generally mentioned in the lower court's post-trial, this court overlooked the fact the trial court never made the specific statutory findings required to support an award. Oh, bullshit. Bullshit. We're not going to look up Kent versus Kent. Prior to trial, it's funny. He's trying a different tactic. Rather than saying Rule 26 trumps everything, pardon the expression. Now we're trying to just say that, awarding things under ARS 25 is without any basis. Oh, it just keeps spinning that yarn. I don't know where the cotton comes from, but just keep spinning that yarn. Prior to trial, Laura made a timely request for findings of fact and conclusions. Well, that might be debatable. That might be very debatable. Petitioner Laura Owens hereby requests findings of fact and conclusions of law with respect submitted for decision in this matter. I think the court did that. I'd have to go back and dig through some things, which I'm not going to do, because we're only at page 11. Well, what the court found was that Laura was a perjurous liar, and there was none of the things she was claiming were factual or based in law, just as the appellate court found with all of David Gingriss's arguments on his appeal. Oh, more bullshit, more bullshit, more bullshit. And yeah, he's just rehashing the same. He's rehashing the same arguments of his appeal all over again. All over again. Let's see. We're talking, court agreed with father's argument. Statute clearly requires that before awarding costs, expenses, and maintaining the court must find that, well, the court found they were necessary. The trial court awarded Clayton his fees, and they were considered reasonable. The breakdown was given. And not only that, the appellate court, smacking Dingus the Douche Canoe on his ass a little harder, has also awarded Clayton fees for the appeal. Now, what would be interesting to know is whether or not they will rack up more charges on this. I'm not sure there will necessarily need to be a response, but there may be from Woodnick Law Firm. Then again, there may not be a response because this is so bad. We're just re-arguing the same points all over again. I think the page count is virtually the same too. The same is true here. Laura asked the trial court for findings of fact and conclusions, but at no time did the court make a specific finding that 150 were necessary to the full prop. Okay, see, now we're just arguing silly things. This is just stupid. All of this is stupid. There's nothing new here that's worth even talking about other than he's got to be the worst attorney in Arizona. You know, maybe the tilted lawyer, the very golden throat, Omar Serrato. We'll go through this and pick it apart from the point of view of a practicing family law attorney and point to a few things. Wouldn't that be marvelous? I may be jumping the gun here, but I saw it and I thought, well, I've got a little bit of time to do a slapdash recording, so why not just skim through and see what we got here? But at the time of the lower court's under advisement ruling on June 24, the court had no factual basis to determine precisely what amount. Remember, he was arguing with Rachel. What fees? Fees for what? Because David thinks that, well, Clayton had no expense. Should have taken Laura's dick up his ass and just walked away, walking sideways, and he wouldn't have had to pay for a thing. Unfortunately, that didn't go so well for any of the other men in Laura's past, did it? So I think Clayton did the right thing. And I think Clayton should consider going after Laura and her attorney for criminal defamation, I think is what it would be. Accusing someone of ARP, sexual assault, and not just once, but with a whole host of women on a TV show where it's virtually impossible to have because there's production crew running around all over the place. He made the threat of maybe we should question all of those women on The Bachelor and see how many he ARPed. I mean, come on. This guy needs to be stopped. He needs to be disbarred, and I think he needs to see some criminal charges. I think he should. I think Rachel Mitchell should be looking at both of them. I hope she is, because this is not proper conduct for anyone who's a practicing attorney, by no stretch of the imagination. And lest I repeat myself, I won't talk again about his past, as was reported by Megan Fox and Schnitzel Ninja on Laura 90's channel, because it's outrageous what this guy has done in his past and what he's trying to get away with here on behalf of Laura Owens, who's equally as, I think, from my view. And of course, opinions are like assholes. Everybody's got one. I think Laura has engaged in criminal conduct. What is fabricating medical evidence? Medical fraud is still fraud. That's still a crime. I don't care if she thinks she's the second messiah of pregnancy twins that just happened to vanish. There are things, there are rules, there are laws for reasons to stop crazy people from abusing people. And as I've said so many times, I feel like I'm going crazy myself repeating it. I believe Laura Owens is an abuser. She likes to abuse and coerce and extort men who don't go along with her scheme of trying to be with her once they realize that she's not an honest person. She's not a person with integrity. She's a person with an agenda. She's gunning for fame and glory and money. She wants to be like her mother, I think, is maybe what this comes down to. Latch on to someone who's got some wealth and some power and some notoriety and, just suckle off that until she's old and wrinkly and there's nothing else to be done. She follows in the molded footsteps of her parents. And that's so sad, isn't it? I mean, really, when we get down to it. Oh, when parents fail, when wealthy, famous parents fail, this is what we get, is this. We talk, he's just blathering on about the motion practice. Motions for new trials, objection to his fees, more of the whining and complaining of Laura not getting her way. We are so we're tired of this. We're tired of this. Rather than addressing Laura's objections, the court, yeah, because they were baseless. Just like her petition for paternity, there was no evidence of any babies ever. Why is she not in prison? I mean, really? How many times has she done this? At least 5, right? There's probably more, probably 6 by the sound of it. That guy in San Francisco who was a football player for a certain college and had a certain degree of fame and then went on to do other things with his life. We know who he is. It wasn't hard to figure out. Good for him for managing to dodge this a little bit, though. Kudos to that. The other guys weren't so lucky. And it's for them that we want to keep this. We want to keep this fresh. Every little jot and tittle filed should be a reminder of the behavior, of the criminal actions of this woman. And we hope that they will be found finally criminal and something will be done to prosecute those criminal actions. Just more accusations of how things didn't go their way and how wrong they are because they didn't go their way. There's no point in reading any of it. Because this court cannot make factual findings in the first instance, it is unnecessary to analyze the issues further. Jesus. Save yourself the headache, folks. Just watch Rachel Juarez chew him to pieces on every one of these points. These are all the same talking points. Absolutely all of them. And then we selectively attach various things. Time Bell Consulting Entertainment Lawyers. What is this? Oh, this is just, we've got selective plucking of fees from Clayton's breakdown, from Woodnick Law. I'm sure there's a lot more than just these few things. I'm sure there's a lot more. All of the back and forth motion practice, all of the pleadings, all of the motions to compel lunch, all of the bullshit. Don't tell me there wasn't time, unnecessary time wasted by David Gingras Esquire.
The fucking douche canoe.
Running up the clock. He knew he couldn't win for his client, is my opinion. I don't think he's quite as ignorant about the history of the case as he pretends to believe, but he has to have some plausible deniability, because if he didn't, all the things he's saying, which he loosely attributes to, well, Laura told me this, he's hoping that's his get out of jail free card. Well, I didn't know. That's before my time. Not if you have binders for every one of the witnesses who showed up in attendance to the trial. That on video, you claim to have thrown out because you had very limited time, even though your client was very poorly on the stand. Oh, that sounds very British, doesn't it? Oh, your client was poorly. She did poorly on the stand. She was feeling poorly. No, she wasn't feeling poorly. Not according to witnesses who were watching her with telephoto lenses. It was not any harder a day for Laura than it was for anybody else there. His histrionics, talking about how stressful and how it was a day like any other and how he'd never seen anyone break down like it. Histrionics. It's all bullshit. It's all manufactured. No one believes you, David. And just as no one believes your client. And he goes on and on. Goes on and on. We talk about other cherry-picked things and says, how can this possibly reach $150,000? But of course, he's selectively editing. So there may need to be a response. It's hard to say from Clayton's side of the fence. And he keeps going. Rule 26 is such a hard-on for him. This is his Viagra to the Supreme Court. You know, he's going to take a Rule 26 pill and just walk in with a hard dick and wave it around to the Supreme Court. Say, look, I've got Rule 26 that was violated. Oh, it's not going to work. It's not going to work at all. Let's just skip. Let's see, what section see here? The court failed to make specific findings. I think he's repeating himself. In her merits brief, Laura argued the trial court's award of $150,000 fees could not be justified under ARS 25 on the basis that she violated a court order compelling discovery. Well, she did violate the court order, number one. She never produced. What she did produce, then she recanted on the stand saying, well, remember she said it wasn't Planned Parenthood Mission Viejo, which is what she said in her deposition. It was maybe Los Angeles or some other place. But she didn't produce them. They couldn't be produced. There were no documents. There was no evidence. Ever. Laura noted Clayton never sought relief under that statute. Therefore, she never had a chance to explain her side of the issue. Oh, please. Oh, go fuck yourself. Oh, this is great. The court dismissed that argument with this terse conclusion. Yeah, you got fucked. And then a few more did it. Let's see, where do we have here? Here, the court made such a finding thus as it was required to sanction Owens for cost and fees. Yeah, okay, well, we know this. Owens did not meaningfully challenge that finding. Again, the court did not err. Well, because he's such a bad lawyer, maybe he missed some opportunities. And that's his fault. Maybe he should own up to that. But that's probably why he has no malpractice insurance. Maybe Clayton should just not only file for defamation, but as part of that, just start placing liens against the Owens properties and farms and the Dingus the Douche Canoe manor and business. I mean, Clayton's entitled to all of the findings of fees. I don't think there's ever going to be a chance to recant that. I don't think there's an opportunity. And I don't think David has the wherewithal to even make a reasonable, cogent argument that might even tickle any sort of reconsideration. He keeps going on about there's no factual basis. Idiot. If this court intended to hold any violation of a discovery order, however minor, could result in an award of unlimited fees for the entire proceeding without any finding as to the reasonableness. This is so histrionic. I mean, it's just so... the conclusions are all wrong. Oh, okay. See, we know it's just going to be more of the regular. It's going to be more of the same. It's just all repetitious. All repetitious. Trial court's UIR contains nothing beyond sheer speculation that Laura's alleged discovery... It was not speculation that it was a discovery violation. What is he talking about? He's making up things that never happened to try and get his client out of it. He needs to be in prison. I'm just going to keep saying it. He's a terrible lawyer. Take away his bar card and lock him up. He misrepresents so many things, which is inappropriate for a practicing lawyer. It's not only inappropriate, it's unethical. And it's a violation of bar rules throughout the country, and certainly the state of Arizona. How many more bar complaints needs to be filed with his name until something happens for him, where he's brought before the court on charges of all sorts of moral turpitude? Is that would it be that, or would it be something else? See, this is where, well, I have to reveal my ignorance and naivete when it comes to legal procedures, because I'm not a lawyer. That are separately mandated. See, it's all the same stuff. I'm right, and the appeals court is wrong because I'm David Gingras Esquire.
The fucking douche canoe.
So for those reasons, because I'm right and Laura's right, and Laura's never wrong, because Laura's a spoiled bitch, the court should reconsider its decision. Oy vey. No, they shouldn't. And I'm quite sure they won't. So then, ladies and gentlemen, what's next? Well, we know quite sure. We know for certain. He's going to continue his march all the way, as far as he can, until they start saying, nope, not interested. Sorry, douche canoe. It stops at the court below. I don't think there's anything. I don't think there's anything in his whining and his brow beating and his dick waving and his chest pounding that's going to get the Supreme Court of Appeals to be interested in this. I just don't. If I'm wrong, I'll eat crow a little later. And then I'll find some recipes for a good dry rub if I happen to be wrong on that. But I'm feeling reasonably confident because there's much smarter people that I've been listening to. We're all of a similar mind and how we seem to know how the system works better than he does as a practicing attorney of 20-something years. He must not be practicing very well. You know, it's like playing the piano. Sure, you can practice your scales, but if you're doing them wrong, is it really practice? No, I think not. It's just fucking around and taking people's money under false pretenses that you can help them as an attorney, as perhaps an ambulance chaser. But that's just speculation on my part because we don't know who came to who. If Dingus the Douche Canoe came to her and said, hey, I can help you out with this, or if in a moment of desperation because there was no one else in all of Arizona, she went to him. But we do know, according to his own claims on his own videos, that he had dinner with mums and dadums. Isn't that bizarre? You have an adult client, very adult in her 30s, and you're having dinner with their parents for private legal cases of the daughter. That's bizarre. All of this is bizarre. Now, it's not as bizarre as what the Hales and all of that circus, but this is at least a 2-ring circus. And the more he tries to push up the ladder of appeals, which isn't, I don't think it's going to go any further. Do you? Put in the comments below. Tell me what you think is going to happen. But I have no doubt we will see a filing from Dingus the Douche Canoe.
The fucking douche canoe.
For the Supreme Court of Arizona. Arguing the very same things that his appeal brief did for the appellate court. And this steamy pile of shit for reconsideration, which is going to get summarily ignored and or dismissed. Those are my 2 cents on the occasion. And I think that's enough for this evening. Let's keep this short. Alrighty. So for today, I think that's enough from...
My name's David Gingras, barely a lawyer, hanging in there. Joining me today is the pregnancy faker extraordinaire, Laura Owens.
So, until next time, until there's more. And I want to cover the idea because I keep having this rumination as I drive about in this blooming spring season of what it takes to be convicted of defamation. Are false allegations of sexual assault and ARP, graping, as some other people use it, is that enough for criminal charges to be brought against Laura Owens and her attorney? I think those are things worth looking at, and at least looking at from a speculatory point of view, don't you think? But I think that's just enough for this evening because it's Tuesday. And we don't need to do too much more for Tuesday. Alrighty, everybody. Be good or not. Make your choices, but make smart ones. Until next time.